Hi, my name is Bethany, and today I wanted to go over some recent things that have been going on with the Judge Rotenberg Center at JRC, the Association for Behavior Analysis International, ABAI, the ABA community, and the autistic community. Due to the length required to go over the information involved in everything that's going on, this will be split up into separate videos as a mini-series titled JRC, ABAI, and a Reckoning. This is the first video where we will start with the beginning of the situation. Judge Rotenberg Center, or JRC, is the only place in the United States and only known place in the world that uses painful skin shock devices called graduated electronic decelerators, GEDs, on disabled people as an aversive or punishment to modify behavior. They do this as part of applied behavior analysis, or ABA therapy. JRC has been in the news due to the fight with the FDA's decision to finally ban the device for use as an aversive in behavior modification. However, this decision by the FDA was overturned because the FDA is not allowed to ban a medical device for a particular use. There has been an outcry in response to the overturning of the decision and more awareness raised through things like #StopTheShock. Many online had started to pay more attention to autistic creator Jennifer Masumba, who has been sharing her personal experience as a student at JRC. Additionally, one group of lawyers from Sweeney Merrigan Law, LLP, has been advertised as putting together a lawsuit against JRC to help get some restitution for abuse victims. As things globally began to overtake everyone's news feeds, substantial actions seemed to slow, with no sign from the FDA that they would completely ban the GEDs rather than banning them for specific use, which is within their authority. However, JRC decided to push the good luck they've had regarding legal matters and launched themselves back into the spotlight when they decided to threaten litigation against an autistic-led nonprofit, NeuroClastic, sending a cease and desist letter. The letter claimed that NeuroClastic has made false and defamatory statements about JRC, specifically citing an article with the results of surveying 900 ABA professionals about the use of GEDs. Specifically, they outlined the following as their main grievances. A quote from Brian Middleton, MED, BCBA, LBATN, that the skin shock in use at JRC is at least 10 times more powerful than a stun gun, and that JRC uses skin shock to treat not answering a question in 3 seconds or saying no. A quote from RBT that JRC uses shock on clients while they are strapped down to a board on the floor. The majority of the individuals wearing GED are black or brown. JRC uses skin shock to treat completely innocuous behaviors like hand play and pressurizing the ears. Proponents of the JRC argue that the use of the GED is used with consent, but built into JRC structure is a systematic stripping of consent to ensure the resident being admitted cannot say no, and all of JRC's residents are capable of consent, even in the absence of having access to using words as communication. The skin shock JRC uses is much more painful and many times stronger than a cattle prod, and a quote from Mason Weiser that JRC's use of skin shock is torture and that JRC has murdered us by electrocution there before. They also address these claims in paragraphs following their overall outline. In regard to the first one listed, skin shock in use at JRC is at least 10 times more powerful than a stun gun, and that JRC uses skin shock to treat not answering a question in 3 seconds or saying no, they say the following. Skin shock is not used on clients for not answering a question in 3 seconds or saying no. The skin shock utilized by JRC is not at least 10 times more powerful than a stun gun. Courts and medical experts have determined that the graduated electronic decelerator GED devices have far less output and are not comparable to stun guns or cattle prods. Basically, they deny the cited reasons for a skin shock and claim that the output of the GED is far less and not comparable to a stun gun or a cattle prod. Brian Middleton, the one quoted in this part, actually reached out to NeuroClastic in response to this and requested an edit to his quote. Here's what it now says. Updated from Brian Middleton, May 11th, 2022. I requested that my quote be updated so that it is more accurate. The original quote stated that the shocks are at least 10 times more powerful than a stun gun. Since the most powerful legal stun gun is 5 milliamps, and the least powerful shock device used by JRC delivers a shock that is 30 milliamps, it would be 6 times the power of a stun gun, assuming the stun gun is at max and JRC is using their least powerful device. If JRC were to use their most powerful device at 90 milliamps per shock, that would be 18 times the power of a stun gun. But I felt that it would be better for my statement to reflect the lesser powered device. Perhaps one thing I could see in favor of JRC's argument here is that some stun guns are created in such a way to interrupt a person's neuromuscular system, thus incapacitating them, and the GED, from my understanding, is only for pain, not for incapacitation. However, other stun guns do only give a shock to stun the person, thus being more similar to the GED. Cattle prods may actually be a closer match, just because they do shock and give pain at the point of contact, whereas some stun guns can basically dump electricity into the entire body. That's not necessarily better, and pain can still travel within the same dermatome. Stun gun or cattle prod, I don't see how they're not comparable, because they all deliver painful shocks to achieve compliance. Information published from the Judge Rotenberg Center describes their own findings regarding the GED. First, in the range of 1988 to 1999, they used something called the SIBIS, which I'm going to call SIBIS, which is the Self-Injurious Behavior Inhibiting System, which was advertised as having a 3.5 milliamp current. They found it came out to 2.025 milliamps RMS when they tested it, and the shock was, according to them, too mild. They found that the device lost its effectiveness for several students after using it for several months, so they modified it to produce 3.4 milliamps RMS, which they found to be a mean and median current of 4.4 milliamps RMS when used on skin. A problem they found with the SIBIS is that it was fixed at 0.2 seconds by the manufacturer, and they couldn't adjust it up. To remedy this and other problems, they decided to create their own remote-controlled shock device, which they named the Graduated Electronic Decelerator, or GED. Yes, they created this thing themselves. They tested on volunteers for 0.2 seconds, the time they felt was too short with the SIBIS, and found the mean and median on actual skin to be 14.6 to 14.8 milliamps RMS. Keep in mind that, according to Middleton, the most powerful stun gun one is legally allowed to possess has an output of 5 milliamps. It already exceeds this number multiple times. In the mid-90s, the GED-4 would be created because some students had adapted to the GED. According to the creator of the GED-4 himself, the device is, quote, very painful. Additionally, the testing on volunteers was 0.2 seconds, but he selected 2 seconds as a typical application duration for use, meaning that volunteer feedback may be rather unreliable. In a report to the United Nations, Mental Disability Rights International, MDRI, was able to consolidate much of this information to be more understandable, saying the following. The first generation of the GED administers 15.5 milliamps RMS of electricity for approximately 2 seconds, with a peak intensity of 30 milliamps. The GED-4 is approximately 3 times stronger than the original shock machine. It delivers 45 milliamps RMS for 2 seconds, with a peak intensity of 91 milliamps. They also mentioned that at the time of writing, most stun guns available on the market would have only 1 to 2 milliamps, although there were some that would deliver 3 to 4 milliamps. 2 former employees of JRC, who left in 1992, had said that the shock is more painful than what the school officials were describing it as. One of the women accidentally got hit on her thumb with the shock and had a tingling up to her elbow on the inner part of her arm for 4 hours. She further stated, "My hand was shaking. I wanted to go home. That's how bad it was." The other employee said that the device had other side effects, stating she had observed students that had burned and blistered skin from the shocks. MDRI makes note that this is before the introduction of the GED-4, since the referenced employees had left JRC in '92. In an addendum to a letter signed by 31 disability organizations, it is noted that the shock delivered to children by either the GED or the GED-4 is much stronger than that delivered by a cattle prod at 0.4 milliamperes or a dog collar at 4.8 to 5 milliamperes, and both of these devices deliver a shock for only a fraction of a second. Additionally, a professor of biomedical engineering at Washington and Lee University, James Eason, was quoted in a 2007 New York Times article as saying, Technically, the lowest shock given by Rotenberg is roughly twice what pain researchers have said is tolerable for most humans. The article also states that the highest shock given by JRC is 3 times the lowest shock given, meaning 3 times more than what was considered to be about twice the tolerable pain level for most humans. As for being punished for not answering a question in 3 seconds or saying no, Jennifer Musumba had published one of her behavior plans from her time at JRC, which included a GED-4 shock for a blatant no and GED-4 shocks for getting out of her seat or bed without permission, pressurize ears, eyes for more than 3 seconds, and many more small things. In a guest post Jennifer wrote that was published on the Autistic Self-Advocacy Network site, she mentioned she was shocked for saying no and not answering staff within 5 seconds. Perhaps on the date of the letter being written, no one had those particular things written on their behavior plans, although I have my doubts. If JRC is getting technical, perhaps they have a problem with the stated 3 seconds versus the written testimony of 5 seconds before getting a shock for not responding. Regardless, it is a thing that happened according to witness testimony and behavior plan documents as additional evidence. JRC just saying, "Nuh-uh," doesn't exactly stand up here. The next grievance outlined was as follows. A quote from RBT that JRC uses shock on clients while they are strapped down to a board on the floor. As rebuttal for this one directly, they simply say JRC does not use skin shock while its clients are strapped down to a board on the floor. Would JRC honestly like to claim that this hasn't happened when there is video evidence of it happening to someone, a video they fought hard to suppress? Jennifer Musumba additionally testifies via guest writing that the 4-point board was also used a lot for shocking students. There was a time that it was happening all the time. JRC claims it doesn't use the board this way anymore, and I am skeptical of that claim, but it doesn't matter because they hurt so many of us that way. They used to bring students into my classroom to put them on the board and shock them, right in the middle of everything else going on. One time they had 2 kids side by side on boards, getting shocked at the same time. We had to walk around them. One kid they brought in was put in a restraint chair. They were shocking him for what seemed like an hour or more. He was drenched in sweat. This kid, now a grown man, has spoken out publicly about this. And JRC's lawyer claimed it wasn't true, and that he was only shocked a few times his whole stay. That is a lie. I saw it with my own eyes. I share Jennifer's skepticism regarding their claims. After all, if they're still using the 4-point board for something else, and that student does something that they consider worthy of a shock, will they not shock them while on the 4-point board? Or are they just letting us know that at least they don't strap them down to the board exclusively for the purpose of shocking them? Or perhaps the board isn't on the floor, thus making shocking them while strapped down to the board on the floor not an entirely truthful statement. Their next complaint is with the statement, the majority of the individuals wearing a GED are black or brown. This is what they had to say about this point directly. It is false that the majority of the individuals wearing a GED are black or brown. JRC does not discriminate in any fashion, including with respect to treatment. The majority of the clients receiving skin shock are Caucasian. There is no statistical data or any other basis for NeuroClastic's claim of racial bias in JRC's treatment program. JRC provides treatment to the most difficult clients in the nation with the highest levels of care and treatment tailored to the clinical needs of each individual. Unlike other treatment facilities, JRC treats and cares for its client populations without resort or reliance on medically unnecessary antipsychotic medications used only to sedate the individuals and cause permanent, potentially lethal side effects. NeuroClastic responded to this particular point with more details as to where this claim came from. To begin, they make note on the use of the term Caucasian by JRC's lawyer as a term that is inaccurate, obsolete, and can reference people from more than 100 different ethnic backgrounds, which they note their use of the word brown likely includes many of the people being referenced as Caucasian. It appears that JRC may have misinterpreted the statement made by NeuroClastic here to imply a racial bias in enrolling students in skin shock, and NeuroClastic explains what they meant in the following. NeuroClastic did not state or imply that JRC selects individuals for the GED based on the color of their skin. However, JRC is complicit in perpetuating systemic injustices and brutality that disproportionately impacts Black and brown people, including brown people who fall under the defunct and inaccurate classifications of Caucasian, like Latinx. U.S. News lists JRC's racial diversity as 82.6% minority enrollment. Essentially, if 82.6% of JRC students are minorities, it is reasonable to assume that those who have the GED would have similar percentages, thus a majority being Black or brown, which is what NeuroClastic had claimed. They go on to make another point, that if sources that reported the GED was historically used on a majority of Black and brown students are accurate, JRC likely disproportionately discontinued the use of GED on Black and brown students, which begs the question, was it even considered necessary for them in the first place? They also point out that it's strange that, according to public sources, 17% of JRC students are white, yet they make up the majority of those on the GED. The next grievance outlined is the following. JRC uses skin shock to treat completely innocuous behaviors like hand play and pressurizing the ears. To this point, JRC's lawyer says, skin shock is not used on clients for completely innocuous behaviors like hand play and pressurizing the ears, or for not answering a question in 3 seconds or saying no. This has already been addressed. Testimony and documented evidence says this has indeed been behaviors that JRC has shocked students for. It could be possible, though I find it unlikely, that it is not on any of the current students' behavior plans, which would be the only way JRC's claim here is truthful. Otherwise, perhaps, they do not find these behaviors to be completely innocuous. Next on the outline is consent. Proponents of the JRC argue that the use of the GED is used with consent, but built into JRC's structure is a systematic stripping of consent to ensure the resident being admitted cannot say no, and all of JRC's residents are capable of consent, even in the absence of having access to using words as communication. JRC's lawyer states the following in response. Under Massachusetts law, applicable to all extraordinary treatment including antipsychotic medication, an individual with a diagnosed mental illness that renders them unable to make informed medical decisions provides or withholds consent through the probate court using the substituted judgment standard. See Massachusetts General Laws, Chapter 190B, Section 5-306A. JRC does not strip its clients of consent, and that statement is false. This argument is much more based on the concept of what consent is, rather than what the court may consider legal consent. Essentially, when a client gets to the point of being considered for GED, they go through a process which involves getting the parents' consent for aversives being added to their IEP, and then generally what JRC will do is they will file a guardianship petition along with a treatment plan. The court appoints an attorney to represent the interests of the student/client, which are separate and apart from those of JRC or of the parent. The attorney hires his or her own expert psychologist at state expense to evaluate the student and advise the attorney as to what position the attorney should take on the proposed treatment plan, including the use of aversives with the student in question. The court must decide 1, whether or not the student is competent to make his or her own treatment decisions, and 2, if competent, would he or she have chosen the treatment. The judge makes the ultimate determination whether or not aversives will be approved for the individual's treatment plan. The opposing counsel can object to the treatment plan and seek to change or remove the plan at any time. If a parent or legal guardian withdraws his or her consent, JRC ceases use of the aversive immediately, whether or not JRC still has court authorization to use aversives with that student or not. JRC's attorney asked us to specifically look at a section in Massachusetts law entitled Substituted Judgment, of which the following is an excerpt. No guardian, temporary guardian, or special guardian of a minor or incapacitated person shall have authority to consent to treatment for which substituted judgment determination may be required, provided that the court shall authorize such treatment when it 1. Specifically finds using the substituted judgment standard that the person, if not incapacitated, would consent to such treatment, and 2. Specifically approves and authorizes a treatment plan and endorses said plan in its order or decree. From my understanding, and I could be wrong here, JRC filing for guardianship, if approved, would make JRC that client's or that student's guardian. Now, that doesn't necessarily mean that the parents just waive all their rights, but I don't know what weight a parent removing their consent from the situation holds if JRC does have legal guardianship over that student. Otherwise, this could mean that the lawyer in that situation becomes the legal guardian for the duration of the court case. I'm not 100% sure. In all of this, perhaps more of what NeuroClastic was trying to communicate is that whether parent or JRC has the say-so, the client themselves have been left voiceless by this process as they are determined to not be competent enough to consent. I also find it extremely upsetting that people honestly came to the conclusion that disabled people would, if they could, consent to painful skin shocks as a therapy. Additionally, NeuroClastic points out that they never said the practice was illegal, only that it was inhumane and undermines the rights of disabled people. They go on to say that if you have to shock someone for trying to remove the painful shocking device, that person hasn't consented to being shocked by you. Legally, the person the court allows to speak for that person may have consented, but it's a clear communication that the person themselves has not consented, even though the court and all these so-called experts believe this person is incapable of giving or revoking consent. The next excerpt on the outline is, again, JRC complaining about the shocks being more painful or stronger than a cattle prod, which, by the way, I have yet to see any factual data coming from JRC to suggest otherwise. The last outline point was this, a quote from Mason Weiser that JRC's use of skin shock is torture, and that JRC has murdered us by electrocution there before. Apparently, the word torture struck a nerve, because this is what Flamia, JRC's attorney, said in response in his letter. JRC does not torture its clients in any way, and the claim in the publication that JRC has murdered us by electrocution there before is false. No JRC client has been harmed as a result of JRC's behavioral treatment program, or in particular, its use of skin shock. JRC's behavioral treatment, including the use of skin shock, has been judicially found to be safe and effective and subject to multiple levels of governmental, human rights, and other oversight to ensure the safety of JRC clients. I wonder why, then, on May 9th, 2010, the Special Rapporteur on the Right to Education and the Special Rapporteur on Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment sent a joint urgent appeal to the U.S. government concerning the treatment suffered by children and young adults enrolled in the residential program of the Judge Rotenberg Center, JRC. The report, written on its correspondence with the U.S. government, noted that these particular members of the United Nations Human Rights Council expressed serious concern about the physical and mental integrity of the students residing at the Judge Rotenberg Center. Furthermore, the United States responded to this appeal by stating that it has an open and ongoing investigation into possible violations of civil rights laws at the Judge Rotenberg Center. Clearly, if the United Nations Special Rapporteur on Torture has a problem with JRC, perhaps it's because there's a possibility of torture? In a report written by Special Rapporteur Juan E. Mendez, the following is stated: the rights of the students of the JRC subjected to Level 3 aversive interventions by means of electric shock and physical means of restraints have been violated under the UN Convention Against Torture and other international standards. Essentially, these students are undergoing torture according to the standards of the UN. Massachusetts State Representative James V. DiPaola voluntarily received a shock, one that he delivered to himself on his forearm. He reportedly leapt out of his seat, cried out in pain, and clawed at the arm that the device was attached to. And this was the milder GED, not the GED-4. He is quoted as saying, "It was torture. It was very painful." Perhaps JRC should go after him for calling even just one shock, which he voluntarily received, torture. The idea that JRC's behavioral treatment program, and in particular its use of skin shock, is safe and effective is absurd. While many have spoken out, and the report by MDRI shares much of the egregious outcomes of these so-called safe programs, perhaps the most compiled and clear message that it is not safe is the FDA's initial ban on using the GEDs as aversives. Despite the ruling being overturned because the FDA cannot ban a medical device for particular use, the findings of the FDA are clear. FDA has determined that these devices present an unreasonable and substantial risk of illness or injury that cannot be corrected or eliminated by labeling. Additionally, they note, although the available data and information show that some individuals subject to ESDs exhibit an immediate interruption of the targeted behavior, the available evidence has not established a durable long-term conditioning effect or an overall favorable benefit-risk profile for the devices. The medical literature shows that ESDs present risks of a number of psychological harms, including depression, post-traumatic stress disorder, PTSD, anxiety, fear, panic, substitution of other negative behaviors, worsening of underlying symptoms, and learned helplessness, becoming unable or unwilling to respond in any way to the ESD. And the devices present the physical risks of pain, skin burns, and tissue damage. The evidence and careful consideration of experts has not changed. To call what JRC does safe is a bold-faced lie. As for the claim, murdered us by electrocution there before, I have not found a source that confirms that someone was killed or had died at JRC specifically by electrocution. However, there have been deaths at and as a result of JRC treatment. Back when JRC was under the name Behavior Research Institute, BRI, a 14-year-old student named Danny Aswad died at the California BRI location while being strapped face down to a bed. At their Massachusetts location in 1985, a 22-year-old autistic student named Vincent Militich died from a seizure after staff pushed his head between one staff member's legs, handcuffed his hand, and forced him to wear a white noise helmet. In 1990, another student at BRI, 19-year-old Linda Cornelison, had a perforated stomach ulcer that was not treated for 2 days because staff ignored her expressions of pain, and these expressions began to be treated as behaviors. She was punished for them. Investigators initially didn't find enough evidence to link BRI to Linda's death, but years later, a Massachusetts court found that the institution, now under the name Judge Rotenberg Center, exhibited negligence in her death. Additionally, the letter notes that JRC is not treating children with skin shock. JRC's clients who are children are all being successfully treated with JRC's ABAI Positive Reinforcement Treatment Program. This is likely currently true because in 2011, Massachusetts Department of Developmental Services, DDS, ruled that electric shock and other physical aversives cannot be used on new admissions to JRC. However, before 2011, this ruling was not in place, and there was no age limit given to the use of the GEDs at JRC. The creator of the GED and founder of JRC, Matthew Israel, stated in a 2007 interview that the lowest age it has been used on, to his knowledge, was 7 or 8. At the end of the letter, although honestly probably typical legal language, the lawyer for JRC says the following: "We await confirmation of your prompt compliance with the demands in this letter." As Autistic People Against Behaviorism, this, coming from JRC, who shock many into submission for the purpose of prompt compliance, this is especially enraging. His choice of sign-off here just really weirds me out, and this might be extra petty of me to include, but it's just so strange because he signs off with "very truly yours," which just gives off this insincere kindness. I do understand that this is probably a typical sign-off for him. It's just such a strange choice for a letter that is threatening legal action. After addressing many parts of the cease and desist letter from JRC, NeuroClastic also had this to say: "The autistic people at NeuroClastic will not, under any amount of pressure or subjected to any form of aversives, retract the aforementioned," in reference to arguing that JRC does not get the actual disabled person's consent to shock them. "NeuroClastic will remove nothing. If you want us to stop accusing you of torture, stop torturing disabled people. We are not bowing to the paltry claims of defamation, because the truth is more brutal and dark than any fiction we could fabricate." The end of NeuroClastic's response urges readers to contact Massachusetts lawmakers to pass H.225, which I believe is House Bill 225, to ban the use of aversives, use hashtag #StopTheShock and hashtag JRCSueMeToo to speak on these issues online, and familiarize oneself with the history of JRC and the disability community. While I've not seen anything further from JRC's lawyer in response to the article being published, which I'm not sure if we will, this situation did not go unnoticed and caused waves not only in the autistic community, but in the ABA community. We'll get into that in the next video. Before you leave, if you find these skin shocks that are done at JRC despicable, and you live in the United States, I urge you to reach out to your U.S. Senator and ask them to pass H.R. 7667, Food and Drug Amendments of 2022. As it is currently written, this bill will ban the use of electric skin shock as a way to reduce aggressive behaviors or self-injurious behaviors, which is what JRC constantly claims as the reason they use the GED. It is easy to contact your U.S. Senator. You can go to congress.gov/members/find-your-member. I'll leave a link in the description box to make this easier. Then put in your address. The next page should show you your Congress members, but since it has passed in the House, we will want to contact the senators of your state to ask them to pass it in the Senate. Click on the contact link that will be part of their info that comes up, and you will likely be taken to a contact page on their website, such as this one for one of mine. You can request an actual meeting if you would like, but knowing my audience, email is probably what you're more likely to go through with. You will likely be taken to a page to fill out a web form. There you will put your info and then urge them to pass H.R. 7667, Food and Drug Amendments of 2022, and why. For me, I might say that this bill will stop the violation of human rights and torture of disabled people at Judge Rotenberg Center, which uses painful skin shock several times more powerful than the average stun gun, by banning its use. It's really that simple, and receiving genuine emails from constituents that aren't just a copy and paste of a mass-produced email often is very impactful for government officials. Thank you so much for watching. If you found this video helpful or informative, go ahead and hit that like button and let me know your thoughts in the comments below. Remember that our outrage and our feelings about what's going on can be used for good things, and yes, we might vent in the comments, but I sincerely urge you to reach out to anyone who can make a change, such as if you're in the United States, your senator, or signing petitions if you're not in the United States, things like that will actually cause some kind of change. Just because, yes, while we might vent in the comments, it's not doing anything unless it gets to the right people. If you would like to, go ahead and hit that subscribe button for more autism related content. I used to upload to this channel every Thursday at 4 p.m. Central Standard Time. However, that has been a bit iffy due to things going on in life. But if it's gonna be a video, it's gonna be on Thursdays, probably. Thank you to everyone who supports me here on YouTube as YouTube channel members, through Ko-fi, and as patrons on Patreon. And a special thank you to my Spinny Stimmy tier patrons, Jack Varney and Philip Noah. Thank you so much for watching. I hope you're having a wonderful week, and I'll see you in my next video. Bye!